Mr. Speaker, the Police Act of 1958 put the provision in that the particulars of young people be recorded, and it's worthwhile reflecting on the reason for that, and the reason is that young people who go through the youth court may have made some pretty dumb decisions in committing the crime for which they were convicted, and so the Parliament of the day back in 1958 made, in my view, the very sensible decision that by keeping their particulars, the police were then able, if you like, to track those young people if they were to offend again. Now, the intention of doing that, I guess, is to hold those young people to account, but also I would suggest that if young people knew that their particulars were held on record, that might have the effect of making them less likely to offend. Now, that surely is the intention of the New Zealand Parliament in 1958, and again was the intention of the Parliament again in 2008. There was an oversight and a mistake was made at that time. This bill seeks to correct that mistake. It enjoys the support of most of this Parliament, quite rightly in my view, in that it does hold young people to account and it does provide a disincentive for them to offend again. And in the second reading speech, I again commend the bill to the House.
Call the Honourable Leanne Dalzell.
I just want to put on the record the conclusion of the regulatory impact statement. Nobody in this House would be surprised to find that I have studied it in depth. The Policing Youth Identifying Particulars Amendment Bill will make no substantial change to the Policing Act 2008. The Policing Act 2008 will be amended, most probably Section 34, in order to reinstate the scope for the retention and use of youth identifying particulars. I forgot what IP stood for a minute, provided for in the Police Act 1958, and that was intended to apply to the 2008 Act. There is no evidence of a policy decision during the development of the Policing Act 2008 to reduce the circumstances under which police could retain youth identifying particulars. Sections 32 to 34 of the 2008 Act aimed to allow police to collect a range of personal information from suspected offenders for the primary purpose of identification prior to charge or summons. This information is to be destroyed unless a conviction is secured following criminal proceedings or the offender's guilt is otherwise established. The legislation was drafted in this way to ensure that police did not have the ability to build up personal information on people who were detained but who were later established not to have committed an offence. The amendment sought is consistent with the original intention of the Policing Act 2008 in that it seeks to retain the youth identifying particulars once the charge against the young person has been proved. As such, there does not appear to be any specific reasons for not reinstating the provisions of the Police Act 1958. So when we actually look at what the bill does, it in fact does what the regulatory impact statement asked it to do, which is to address sections 34 and 34A of the Principal Act. And when we look at the Principal Act, we find that it sits within a part of the Act called Powers, Operations and Offences, and it specifically talks about identification of people detained by police. Now, unless somebody was an incredible technical expert, there is no way that you would know from the face of the words in this statute that this allowed the police, or did not allow the police, to retain the information for people who had been convicted. It certainly on the face of it says that the information cannot be detained for the purposes of for those who are subsequently released. They're only detained. So on the face of it, there is no way that anyone would know that that was the case. And in fact, that's backed up by the debate in the Hansard on the policing bill as it occurred on the 26th of August 2008. And in fact, the debate on Part 3 traversed two dates, one the 7th of August and then again it was picked up on the 22nd of August. And in fact, there were only 2 speakers on that part. The Honourable Annette King, obviously speaking as the Minister to introduce the part in the committee stages, and one Chester Borrows, who took 2 calls on the clause to show the National Opposition's support for the updating or bringing current policing regime into the modern era, to quote Chester Borrows, with a very brief but obviously meaningful contribution to the debate. But what I thought was extraordinary, given the debate that we've had in this House today from both the Green Party and the Māori Party, is why did they say nothing about the legislation, about this part at all? They didn't even contribute to the debate on it. And in fact, the amendments were agreed to, and Part 3 was amended as agreed to. They were agreed to without a division being called. So there was no focus on this whatsoever. And I would have thought if it was such a point of principle, then it would have been dealt with, because on the face of it, the bill as it then was looked like it was doing what we are making it do now. So if it was such a big issue, why wasn't it raised at the time? Now, I myself would probably say that I would take advantage of an opportunity to have a go if I'd felt really strongly about something. I mean, if the government was bringing back an employment relations amendment, or bringing back, something that I felt particularly passionate about, then I guess I would have a go, even though I felt that it would be taking advantage of a technical error that people didn't realise was being made at the time. But we would have had a field day with it, absolutely. But that's not the case here. This is a case where the whole of the Parliament understood completely what they were doing, and the technical writing of the law did not deliver on that understanding. And that's all we're dealing with here, is just a technical error, a draftsperson error, and a Parliament made up of human beings. We're not all legal professionals with the technical skill of the draftsperson, and I certainly wouldn't pretend to even begin to have that. And I did take always great care around the wording of legislation, and even I didn't get it very right. If we look at the financial advisors legislation that our select committee had to virtually completely rewrite when it came back to the House under this government. So there are occasions where people get it wrong. I think if people do get it wrong, then the Parliament has to be able to front up and make those amendments. And I don't think that it's an opportunity to relitigate any of the issues that may have been outstanding with the previous bill, even though I've just admitted to the fact that I would be that hypocritical if I kind of got the opportunity to do it around an issue that I felt passionate about. But I just don't think that this fits the bill. What this bill does today is actually correct a technical drafting error that prevented the intention of this Parliament being expressed. And I think that's all it does. And I don't think that it is appropriate for the opportunity to be taken to relitigate, and certainly to cast aspersions on whether this is being dealt with on a particular day in order to avoid the full scrutiny of this House. The full scrutiny of this House has been applied to this part. It was applied on the 7th of August 2008 and again on the 26th of August 2008. It has had substantial consideration prior to the bill even being introduced, as evidenced by the fact that it had overwhelming support as a piece of legislation. We don't often get pieces of legislation where there is such unanimity across the House, and I feel that on this occasion it is important that this proceeds under urgency through all of its stages so that we can correct a technical error and to right a wrong.
Called David Clendon.